Right, rent repayment orders. Okay, so rent repayment orders are horrible things for landlords. Horrible things for landlords. And one of our guests here today has been a guest on our has been a member here for a long time, and I know that I helped her out with something some months ago, and it would be great to touch base to see how you got on. But this was very applicable to her. Because there was some subletting going on in a property in the form of a HMO. Right, so rent repayment orders. So firstly, you guys need to note that a tenant can apply for a rent repayment order if any of the below apply, okay? So let's just look through them. If a landlord is convicted of using threatening violence for securing entry into premises under Section 6 of the Criminal Law Act, if a landlord has been convicted of illegal eviction or harassment under the Protection from Eviction Act, if a landlord is convicted for failure to comply with an improvement notice under the Housing Act 2004, if the landlord is convicted for failure to comply with a prohibition order under Section 32 of the Housing Act 2004, breach of a banning order under the Housing and Planning Act 2016. So if you've been banned as a landlord and you've breached that, the tenant can apply for a rent repayment order. And the most common ones, having control of or managing an unlicensed property under Section 95 of the Housing Act, and having control or managing an unlicensed HMO under the Housing Act 2004. So let's look at the most two common requests for rent repayment orders in our industry. And it is quite simply, if your property requires a license, whether that be an additional license, a selective license, or a mandatory HMO license, and you as the landlord do not have one, you're in trouble. What does a rent repayment order look like? What does this mean to you financially? Okay, well, what it means is that the tenant can make an application for you to pay them back 12 months worth of rent. 12 months worth of rent. Now, let's look at a HMO, right? I had a rent repayment order against one of our landlords, and the rent was $450 a month for a room. Tenant had made a rent repayment application for 12 months worth of rent. There were 5 other rooms in this property. What do you think the tenant of room 4 did? He went and told all of the other 5 what he was doing. And all of a sudden, the landlord had got 6 rent repayment orders for £5,400 each. I'm just working out the figures. A total repayment claim of £32,400. Now, that's worse than any fine that I'm telling you that I'm talking to you about today that will be levied on you. And all that money is going back to the tenant. So there's a real reason for tenants to do this to you if you get it wrong. Now, there was a case recently, why I'm talking to you about this, called Rakusan v. Jepson, where in this exact scenario, there was a property that was operating as a HMO. It was operating to, and I'm just going to try and keep the story simple, to let's say I'm the tenant, Ali Durant is the landlord, and Mr. Smith is the owner. So Mr. Smith, under a rent-to-rent contract, let this property to Ali Durant under a management contract, rent-to-rent contract, not an AST, a rent-to-rent contract to Ali Durant. Ali Durant then let the property to 6 people as a HMO and didn't have a license. Okay. Mr. Smith, bear in mind, knows nothing what Mr. Ali Durant is doing because he's got his agreement, he's having his rent and he's happy. Right. So what happened was there was no license. It was a HMO. Tenant took the landlord to court. But the landlord didn't go for Ali Durant because what the tenant thought, the tenant didn't go for Ali Durant because what the tenant thought was, Ali's probably got no money because he doesn't own this property. I'm going to go for Mr. Smith because Mr. Smith is the legal owner of this property and I've got more chance of recovering my costs. Now, They went to court. They went to the upper tribunal, and the upper tribunal agreed with the tenant and ordered the superior landlord to pay back the rent that he had never received from this tenant to the tenant under a rent repayment order. The landlord, the head landlord, was not happy about this because he thought, well, I haven't received that rent. Why am I going to pay back that rent when it was Ali Durant that received that rent, not me? And he took it to the Court of Appeal. And thankfully, the Court of Appeal made a ruling that the superior landlord should not be held responsible for any rent repayment order requests. The person that granted the tenancy agreement should be responsible for rent repayment requests. So as you can see back on this slide, a superior landlord now cannot be pursued. So if you're the head landlord, you cannot be pursued for the rent repayment order. Now, it's important to note, guys, that there are many rent repayment orders going on in court at the moment, many applications to court, because it's a quick way of tenants making money. And we all know whenever tenants can make money, they'll find a loophole and try and do so. There's also solicitors and people out there doing exactly what they did when deposit registration came out, and they're offering a no-win, no-fee case basis. So if they see that somebody's got a good case, they're working for them for free on the basis that they get some of the money back. The average award being made in court is 75 to 80%. So in the case of 32,400 being made, if 80% of that was awarded, the landlord would have been told to pay back £25,920 of the claim. So this can be very, very, very costly, guys. So please do not fall foul of any of these items that we've discussed here, because other areas that may affect you is improvement notices or prohibition orders.